Tenakoto katoa. Good afternoon, everyone. My name is Joel Colon Rios. I am a professor of law at Victoria University of Wellington and director of the New Zealand Centre for Public Law. For more than a decade, the New Zealand Centre for Public Law has hosted a series of lectures by national and international public office holders designed to make the work of important public actors more accessible. Today, we're honored to host Amokura Kawharu, president of Te Aka Matua of the Ture. Before being appointed president of the Law Commission in 2020, Amokura worked as an associate professor at Auckland Law School, specializing in commercial and investment arbitration, property law, and international economic regulation. And before that, he practiced commercial law in Auckland and Sydney. Amokura will speak today about the changing roles and responsibilities of law commissioners. She will speak for about 30 minutes, and there will be an opportunity to ask questions at the end. Amokura.
Kia ora, Joel, and tēnā koutou katoa. Thank you all for making time to come along and listen to what I have to say today. And it's I'd say it's great to see you, but actually I can only see a screen of myself. But I know that you're there, so it's really great to have an audience and an opportunity to share some of my reflections on the role of Law Commissioner since taking up the role of President in May last year. Since this is part of an office holders series, I thought that I'd concentrate on aspects of the Office of Law Commissioner rather than on any of the particular substantive issues that we're covering in our current work programme. Law Commissioners are appointed by the Governor-General on the advice of the Minister who's responsible for the Commission, and at the moment it's the Minister of Justice. It's usually the Minister of Justice, but could be an Associate Minister, for example. We normally hold office for 5 years, although we can stay in office until we're replaced under the carryover provisions in the Crown Entities Act. One of our new commissioners, Justice Christian Whātua, who will be starting with us next week, has been appointed for a term of only 1 year, as he's been appointed for a special project on tikanga. There's very little in our Act, the Law Commission Act 1985, by way of a job description. I've indicated in the title that the role is changing. The role of a law commissioner is a changing one. And what I mean by that is that the role has changed and continues to change, reflecting its modernisation, changes in administrative responsibilities, budget issues, and other factors. So if I was to describe my role in a nutshell, it's that I normally wear four hats and currently 4.5. So I thought I'd begin by describing these various hats. My first hat is that as President of the Law Commission, under our Act, I'm also the Chief Executive. And so I carry the management responsibilities that attach to the Office of Chief Executive. The General Manager of the Commission is one of my direct reports, and we meet weekly to discuss budgets, any issues in the provision of corporate services, IT, information services, health and safety matters, staffing, and so on. The General Manager is also usually responsible for overseeing the development of our various corporate policies. I said that I wear 4.5 hats, and the half hat that I wear at the moment is that of General Manager, since the position is currently vacant. So we have 2 people on part-time secondment from Deloitte who are taking care of the financial aspects of the GM role and some of the more general GM responsibilities, but the rest presently fall to me. I should also say that all commissioners undertake general management functions, and we all muck in. We are very small, so embedding our values and achieving our mission means that we have to do work that in a bigger place might be taken care of by others. So to give you some concrete examples about the life of a law commissioner, our latest commissioner, Jeff Shercliffe, who started just a couple of weeks ago, has bravely taken up the task of completing a governance manual for the Commission. and he represents the Commission in the Ministry of Justice-led Governance Steering Group, which is a group of entities monitored by the Ministry of Justice, which comes together to discuss best practice on governance-related matters. Another commissioner, Helen McQueen, she oversees our Official Information Act responses. I recently wrote a koha policy, and last year I wrote a Te Reo Māori development plan for the Commission. So that's management. My second hat is a governance one. Again, under our legislation, as President, I'm also Chair of the Law Commission's board. Although, unlike many chairs, I don't appoint the Chief Executive. I haven't managed to take one hat off and put another one on. I wear them simultaneously. So I don't have a role in holding myself to account. My remuneration, for example, is determined by the Remuneration Authority rather than the board. And it's not directly connected to my performance in the job either. At our bi-monthly board meetings, I present a President's report outlining our progress on our strategic goals. But as all of the Law Commissioners are also board members, this isn't so much an executive report in the usual sense, but an opportunity for all of us to record and reflect on our progress and agree on any actions. Or at least that's how I approach the reporting aspect of the CE part of the job. My third hat is the Law Commissioner role. So as Law Commissioner, I currently manage a team of 5 advisors, we call them legal and policy advisors, working on 2 related projects, the reviews of class actions and litigation funding. And these 2 reviews are taking place in a wider context of access to justice initiatives and are running together in parallel because of their overlap in content. So within this project, we've published 2 consultation documents so far, a big 380-page issues paper, which we published in December last year, asking whether we should have a class actions regime and whether litigation funding is desirable in principle. And then last week, we published a second supplementary issues paper or consultation document. It's about 180 pages long, setting out a preliminary view that we should have class actions regime, we should have litigation funding, and just detailing some technical proposals, if you like, for a new class actions regime. Anyway, so that's my sort of 2 projects that I'm managing at the moment. I contributed to some of the writing of these issues papers, but the vast majority of the writing of these papers was undertaken by the team. We all reviewed each other's work. We have a flat structure within the teams. So it makes little difference to advisors if you're the law commissioner. If they think that you are going off piste, then they will let you know. We might work through 2 or 3 iterations of drafts of whether they're policy papers or draft chapters before providing drafts to the other commissioners for review and board sign-off. And that's the other law reform role of law commissioners, to work together as a commission and agree on the broad policy directions of each project. We review the drafts of all our publications and can have a significant influence on them through this review process. I think I also want to say that the commissioner level peer review is one of the most enjoyable aspects of the role for me, as it's an opportunity to work collegially across some very interesting and often difficult law reform problems. And I think when working within a project, it's natural to become a bit wedded to one position or another. So the opportunity to discuss these with the other commissioners helps to promote the thoroughness of our work, really test our ideas and also improve the consistency of our recommendations across our various different projects. The fourth hat I wear is the President's hat. And apart from the roles I've described just a moment ago, which are all provided for in our legislation, the job of President is really defined by the person who holds it. I think there are two key responsibilities that attach to the role of President. One is promoting a good working relationship among commissioners and a positive tone and expectations for everyone who works in the Commission. And the second is representing the Commission in official settings and through engagement such as this. So it might seem odd that as a Law Commissioner, I described the Law Commissioner role as my third hat. The reason I listed the roles in the order that I did is because it reflects the time I spend on each. I spend more time on governance and administration than I do on law reform work. I think before taking on the role, having read some of our recent annual reports and other papers, I knew that there would be some quite significant administrative aspects to the role, but I also think I underestimated the time commitment to those parts of the role. I think that being the President role, which I mentioned right at the end, the fourth hat, is harder to quantify in terms of time commitment because part of it is just setting a good example, but it's the least time consuming. For the other commissioners, the balance is quite different. But as I said, all commissioners do have some management and some governance responsibilities. Apart from not really knowing exactly what the mix of the role was before I started in it, there's actually quite a lot that I didn't know about the Law Commission before becoming interested in this role. For example, I didn't know that the Law Commission was an independent Crown entity or even what that meant. I knew it had produced an excellent report on arbitration law in 1991. I knew the Commission had produced an excellent report on land transfer system reforms in 2010. And both of those reports helped to inform my teaching and research in my prior time as an academic. And I think that's quite a common perception of the Law Commission, that we produce substantial reports that lead to major reforms in core areas of the law. The Commission was established by the Law Commission Act 1985 with an ambitious purpose, and I'll just read from the Act, to promote the systematic review, reform and development of the law of New Zealand. So in further explaining what we do, I thought I might now turn to say something about what we replaced and why through a potted prehistory of the institution. So semi-law reform institutions have been in place in Aotearoa since 1937. When the then Minister of Justice and Attorney General, Rex Mason, established and chaired what was called the Law Revision Committee. There was no formal, sorry, just have to get rid of those off my screen. There was no formal constitution for the committee, and it comprised members who had been invited by the Minister to join it. Proposals for law reform projects were generated by committee members and sometimes by the Law Society or the Department of Justice. Papers were often produced by members of the committee, or sometimes academics and others were co-opted. The system was replaced in the 1960s by a new Law Revision Commission, which was later renamed the Law Revision Council. What this body was an umbrella body that oversaw the law reform work of a number of smaller specialised committees. So for example, there was a Property and Equity Law Reform Committee, and there was also a public and administrative law committee. These committees were more specialised and were viewed as being more effective because they were more specialised. But as with the predecessor model, membership was only part-time and voluntary. In addition to the work of these committees, law reform work was also achieved through other committees, government departments and special commissions, as I'm sure all of you will be aware. But the generally voluntary and ad hoc nature of the committee structure that we had in place had some serious limitations. The committees weren't supported by their own research capacity. They weren't supported to consult or engage with people. So consultation could be extremely limited. And the committees were really limited to work of quite a discrete and technical nature. There was no institutional purpose or mandate of the committee structure or any institutional accountability other than the usual accountability of the parliamentary process. In other words, their recommendations still needed to pass through Parliament. Overseas, from the 1960s onwards, law commissions were being established in England and Wales and Scotland in the mid-1960s, in Australia and across Canada from then onwards also. So that also contributed to the sense that what we had in New Zealand was maybe not really fit for purpose. Other factors that also contributed to the idea to create a law commission, better recognition of the complexity of our society and the fact that we're not all homogenous, the increase in volume of statute law and increasing influence of international law on domestic law. So in light of all of these various factors, the Labour Party included the creation of the Law Commission as part of its 1984 election manifesto. The Labour government, of course, was elected in 1984, and under the leadership of Sir Geoffrey Palmer, a Law Commission bill was introduced and passed in 1985. And then the Law Commission began its operations in 1986. The Public and Administrative Law Committee from the old system survived in a modified form to become the Legislation Advisory Committee, which is now called the Legislation Design and Advisory Committee, better known as LDAC. But the rest of the committee infrastructure was dismantled. So, as I mentioned, the Law Commission was established in 1985 with a really ambitious purpose to promote the systematic reform of the law. How we go about doing this has changed over the years. And so that's what I'm going to turn to talk about now. The early annual reports of the Commission and from conversations with early commissioners suggest that initially commissioners had a greater hands-on role in law reform projects. There were more law commissioners relative to policy advisors, more projects on the go at any given time. For example, in 1987, there were 5 law commissioners, 5 legal staff, and 18 projects on the work programme. Today we have 3 commissioners, next week it will be 4. We have 14 legal staff, a small army of law clerks, and 7 projects on our current work programme, 6 of which will be active as of next week. Some of this difference is due to the Commission establishing itself in its early years with a very wide-ranging work programme and a phased approach to recruitment of legal staff. But I think apart from the establishment factors, there were other factors that were also at play in helping to explain that difference. I'm going to go back to administration because I think the first concerns the accountability and compliance obligations imposed on the Commission under the Crown Entities Act 2004. It's of course important that the Commission is accountable for the money that we receive, and you could say that it is a price of our independence. But the obligations are also quite onerous, and I believe one of my predecessors tried to argue against the Commission coming under the Crown Entities Act, but was unsuccessful. So we have the same reporting obligations as the Commerce Commission, for example, although we are less than a tenth of their size. One of the really fun exercises under the Crown Entities Act, so far anyway, has been the development of our statement of intent together with the other commissioners last year. A statement of intent is essentially a medium-term strategic plan, which is delivered to the Minister of Justice every 3 years. So we had a very long list of ideas about things that we could focus on, and we whittled it down to basically 3 broad areas of focus, which are Te Ao Māori, workplace culture, and stakeholder engagement. One of the more difficult and more vexed issues under the Act concerns how our performance should be measured and audited as required by the Act. There's no internationally agreed methodology or standard practice for auditing the work of law commissions. That's partly because we all have slightly different mandates, but partly also it's just a very difficult thing to do. Our projects can be very different, which also makes uniform auditing or uniform measurement quite difficult. In the past, we have tried various things, for example, peer review and a grading system applied by the responsible minister, who would give us a mark out of 10. We have spent a lot of time over the last 16 months working to embed new performance measures that we instituted last year as part of our new statement of intent. And as part of that, we've also worked to create new data capturing mechanisms to make sure that we have things that can be counted by our auditors. We've adopted a mix of new measures. Some are quantitative. For example, did we receive the expected number of submissions in response to our issues paper? And did we publish our target number of publications over the year? Some measures are qualitative. For example, we receive feedback from members of our expert advisory committees on the quality of our reports. And we use a sliding scale system where we are graded on a scale of 1 to 5. And this may sound familiar, as it's the same type of system that we had for lecturer evaluations at Auckland Law School. The other set of measures we have developed are impact measures. For example, we count the number of judicial citations to our work in a given financial year, which also brings back memories, maybe not happy memories from my time as an academic in the PBRF. As another impact measure, we now also measure the implementation rate of our reports over a rolling 10-year period, with a target rate of implementation of 60%. Whether our reports are implemented or not is entirely a matter for the executive and then Parliament, and it's something that we have no control over. But at the same time, if few of our reports were implemented over a prolonged period of time, then we should ask, what is the point of a law commission? So that's really the premise, if you like, for us agreeing to measure the implementation rate of our past reports. We do have to be careful, though, that we don't become beholden to the audit process when deciding what to recommend. For example, in our alcohol project, which was reported on, I think, in 2010 or thereabouts, almost all recommendations in that report were implemented, except some of the most important ones. So there's a balance to be struck, but we should, of course, keep making bold and progressive recommendations when they are called for. Happily, our current count for the current annual report is that we're sitting around about 75% implementation, which holds up quite well internationally too. So I think what I'm saying in terms of the change in the roles is that commissioners, but most especially the president, now spend a fair amount of time on administration. Another change is that we do far less self-initiated work. In fact, we hardly do any at all. By way of contrast, some of the Commission's early big projects were self-initiated. For example, the review of arbitration law was a self-initiated project. So, unlike many overseas law reform agencies, we do have the power to self-initiate work. And the thinking behind that is that, or was that, the Commission should have a wider constitutional responsibility to contribute to the sort of healthy state of the statute book. In addition to the arbitration project I mentioned, another example of self-initiated work is the Commission's study paper on Māori custom and values that was published in 2001, which has become one of our most highly cited publications and has made a significant contribution, I think, to the understanding of tikanga Māori as a legal system. We've recently self-initiated another study paper project concerning emergency powers. Professor Janet McLean, who many of you will know, has been engaged by the Commission to lead this work. And it will focus on New Zealand's legal and institutional framework for responding to pandemics and other threats. But as I said, the power to self-initiate work is hardly ever exercised, mainly due to resource limitations. The other factor relates to implementation, which I was talking about before. Self-initiated work has been less successful than government-referred work in terms of implementation. And it's probably stating the obvious, I think, that work which is wanted by government is more likely to be implemented. Although there's always a chance of a change in government and a future government wanting it less. So almost all of our work, therefore, is now referred by government or occasionally Parliament. An example of a parliamentary reference is section 202 of the Evidence Act, which requires the Commission to review the operation of the Act every 5 years. And we expect to be referred the next review over the next few months. So if anyone has any ideas about hot topics for the reform of the Evidence Act, please do let me know. One area we thought in the last review that still needed further attention was the right to silence. So I think there's scope for having quite a focused review on evidence law and that new reference. So in terms of the work that comes to us, there's a Cabinet Office circular which sets out a number of different criteria for assessing what would be an appropriate reference of a project to the Commission. They include areas of law that require fundamental review or independent consideration because of a significant difference in views. And at the other end of the scale, another criterion is that the work is of such a technical lawyer's law nature that it might otherwise be overlooked. So keeping this general law up to date has also been a big part of the Commission's work. So our current programme reflects a good mixture of these different concerns. So apart from the emergencies work that I just mentioned, on our current work programme, we are reviewing class actions and litigation funding, succession law, surrogacy, and adult decision-making capacity. From next week, we will also start work on our tikanga project. And so with the exception of the emergencies project, all of this work has been referred to us by our responsible minister. In the case of the tikanga project, however, this is also a reference that we worked very hard to receive. So a third change of note is that the kinds of work we do has changed. The Commission has always been involved in doing big law reform projects. Again, the arbitration review I mentioned was a big project. Also, the reviews on companies law and Māori fisheries are other examples of quite sizable early law reform projects. But in the past, the Commission also often did some quite small scale work on very discrete issues. Today, a small project is one that would take around 12 to 18 months. Overall, we work on bigger reform projects and we produce longer reports. So I had on my desk this morning a copy of the DNA report that we published last year. It's 560 pages. I also have on my shelf a report from 2001 on legal privilege, which is about 20 pages long, excluding the appendices, which are also about 20 pages long. So we don't do work like that anymore. And I think this might reflect a range of influences, including the maturity of policy development infrastructure across government. So work can be done elsewhere. Difficulties in finding space on the legislative agenda. So working out what's the best use of our limited resources. This might suggest that doing fewer but larger projects might make more sense, although I'm not entirely sure about that one. There are also very high expectations of wide engagement, public and stakeholder engagement, and this also impacts on the scale of the work required and lengthens the reform process. Again, if I use the example of the two reports I mentioned just a minute ago, the DNA project was a 4-year project and there was very extensive stakeholder engagement on that. There was no mention of any consultation in the other shorter project that we reported on in the early 2000s. And the class actions and litigation funding reviews that I'm overseeing, we received 51 submissions on our issues paper published last year. We received submissions from all the usual suspects, the Law Society, the big law firms and various lawyers. But we also heard from Te Hungaroia, NZX, the Insurance Council, a number of regulators, Commerce Commission, MB and others, the Solicitor General, Consumer New Zealand, and so on. I think receiving regular submissions from Te Hungaroia actually is an important and noteworthy change in law reform practice. For Ngā Huarahi Whakatau, which is our project on adult decision-making capacity, we're thinking very hard about how to undertake engagement, and it will be, I think there'll be a steep learning for us in this project as we need to ensure that the way we do our engagement is accessible to the people who need to be heard in that particular project. So, for example, today we are going to publish the terms of reference for Ngā Huarahi Whakatau, which is the name of the project, in multiple different formats. It will be available, or they will be available in large text, Braille, NZ Sign Language, Easy Read, and maybe others. At least those formats. Okay, just looking at my time, I think I might conclude with a little story about our Māori name. And Joel introduced me as president of Te Aka Matua o Te Ture. This name was given to the Commission many years ago, although I'm yet to find out by whom or why. It translates as the parent vine of the law. And within the Commission, we regularly, or perhaps even ordinarily, now use our Māori name. Some of you may be familiar with the pūrākau or story of the parent vine that Tāwhaki used to climb up into the heavens. And at the foot of the ascent, he and his brother Kārehi find their grandmother, Whaitiri, who guards the vines that lead up, excuse me, into the sky. Kārehi was impatient and he went straight for the first vine that he could grab hold of. And it was an aka taiaka, or a hanging vine. So he started climbing up and then he was blown about violently by the winds and fell to his death. excuse me, but following his grandmother Whaitiri's advice, Tāwhaki takes hold of the Aka Matua, or the parent vine, successfully climbs to the heavens and receives the baskets of knowledge. So I recently came across a Ngāti Whātua manuscript, which was translated in the 1950s, but it was written much earlier, and it slightly varies the script. In this version, Tāwhaki instructs his brother to go home to care for their families. It's much less dramatic, but the same messages, I think, are clear. The path to true knowledge can be long and difficult. It may be important to hear from others when deciding which path to take. And it may be important to report back to stakeholders along the way. So some things don't change then, because this was all true for the Commission in 1985, and it remains true today. All right, Joel, I've completed my part of talking, so I'm open to taking any questions.
Thanks very much, Amokura. I really enjoyed that excellent presentation, and I am sure everyone else did too. I particularly appreciated your comments about the real-life examples of the work of law commissioners, your insights about the internal structure and working of the Commission, as well as your reflections on its historical purpose and the present strategic plan. And I also found the discussion about evaluation mechanisms quite fascinating. We now have around 20 minutes for questions. If you can please use either the chat function or the Q&A function to ask your questions, that would be great, and I will convey them to Amokura. I think we already have one question from Mike Cook. So Mike asks, he says, I'll just read the question. He says, if I heard correctly, you said that there is management the law commissioners do. So the law commissioners do management work, which the Ministry of Justice oversees, and there is a board which you and the law commissioners are members of. And the law commission is a small organization. And then the question is, do you think this is too much management / governance? Some may say bureaucracy, and perhaps some of these resources would be better used for law review.
Yeah, it's a really great question. As I said, I'm surprised at how much of my time I spend doing management and administration work, and it has changed over the years. The Crown Entities Act has a lot to say for itself on that front, and that is actually why it was suggested that the Law Commission was too small to fall under that legislation and have to comply with all the various reporting requirements. But it is the way, it just is the way that it is. And I also suggested that I think it's potentially a price of our independence. So we are given a great deal of latitude in terms of how we do our work and what we say. But we're also given several $1 million a year, and somehow we need to be able to show that we are spending that money well and administering our funds efficiently. And so that's part of the performance measures really is the imposition of disciplines on us to make sure that all our work is carefully planned out in advance, scoped and budgeted. And actually this is something that academics are totally used to, because when we apply for funding, we have to go through that same discipline. So, it's really tricky. Yes, we do spend a lot of time doing this administration work, and law commissions are not cheap. So actually if you add up, all the time, it's quite a significant investment. But on the other hand, there are good reasons for it. I mean, one thing that we have been thinking about in the Commission as we recruit for a new general manager is how much of the work that I currently do can be picked up by a general manager, hopefully lots of it, so that I can then spend more time doing law reform work. But on the other hand, we probably only have enough money to recruit one person to fill the general manager role. And we need that person to be able to deal with our finances, payroll, creditors, budgeting. So finding someone who can do all of that work as well as do some of the other things that we have been doing and put that person into for there only to be one person is actually quite difficult. So it's an ongoing challenge. It's an ongoing challenge. I don't think I can answer that question any better than that. Yeah.
Thanks very much. Let's see if we have any. I think people are still writing their questions in the chat. I think so. I'll just ask one myself in the meantime. So part of the work I do is comparative, and I often wonder, to what extent your work is comparative as well. To what extent, and then if it is, to what jurisdictions you usually look to.
Great. Okay. Thank you. Yes. So I guess we have what we would call our usual comparative jurisdictions. They would be Australia, Canada, and the UK. I think in most reviews we would always look at those Anglo-Commonwealth jurisdictions. After that, it depends on the subject matter. So, for example, in Ngāpuhi Whakatau, the project on adult decision-making capacity, one of the reasons that work has been referred to us is to make sure that Aotearoa is meeting its obligations under the UN Convention on the Rights of People with Disabilities. So one of the things that we need to do in relation to that project is work out, well, who are the leading jurisdictions in terms of implementing that convention, because it may not be Canada, it may not be Australia or the UK. So we kind of have, like I said, that core group of jurisdictions that we turn to, but in particular projects, we might have to think about other jurisdictions as well. In some projects, again, this is the influence of international developments. There may be an international template that has been developed, which has happened in arbitration law, insolvency, and in some other areas. And so, again, we look at, well, what would be the exemplar jurisdictions, which jurisdictions have implemented those templates and done a good job. The other really difficult and exciting piece of comparative work that we've been doing, Joel, is actually around tikanga, and how do we view tikanga, as a legal system in its own right, but also then how do we draw from it and accommodate or integrate or provide for it under state law. And we have to ask ourselves some quite difficult questions about why would we do that? When should we do that? And how? So I think comparative law disciplines are important and have always been important to the Commission, but I think they're increasingly important because of that other jurisdiction closer to home that we also need to be thinking about.
Thanks very much. We have a question from Hannah Wilberg, who also says hi. Yes. So she says there are a few points I would like to pick up on. The first one is on whether reports are implemented. So the question is, do you see a role for the president in that regard? For example, shaping projects, tailoring reports, subject to what you said about still saying what's important and lobbying afterwards. Second, on consultation, you gave some detail of what you are doing to reach your stakeholders for one current project, and you mentioned the importance of Te Hunga Roya. Could you say a bit more about how you go about proactively reaching out to a variety of groups? And finally, on the tikanga project, that's exciting. Could you say a bit more about it? Thanks.
Okay. So 4 questions. In terms of shaping projects, I really briefly mentioned the Cabinet Office Circular. That really sets out the process for determining what projects will be referred to the Commission. So, as I mentioned, we have a power to self-initiate, but we hardly ever exercise it. all our other work is referred to us by government through the Minister of Justice. And so for that work which is referred to us, the Cabinet Office Circular applies, and it sets out the criteria as well as the process for referring work to us. We have to present a proposed work program to the Minister every year. So we receive law reform suggestions all the time, actually from members of the public, from lawyers, from the law societies, and we maintain a schedule of law reform proposals. And then we think about how we go about doing a shortlist of those projects. How much support do we think particular law reform projects would have? How much need is there? What sort of capacity would be required? And so on. So we come up with a shortlist. We then present that to the Minister, and at the same time, the Minister sends a letter to all their Cabinet colleagues and asks them to apply the same criteria and come up with law reform project proposals. So there's our list and then the Minister's list. And then our work program is developed from a discussion around that list. In practice, almost all of the work which is referred to the Commission is work which has come through the Minister's list rather than ours. The tikanga project is an exception, and the class actions and litigation funding reviews are also exceptions. They were ones that we had wanted included on our work program. So in terms of shaping the projects or determining what projects come to us, that's the process for that. Once they've been referred to us though, then we are free to determine how we go about doing them. So we draft our own terms of reference. We consult with the Ministry of Justice or the other, it may not be the Ministry of Justice, it may be the Ministry of Health, whatever is the administering or likely administering ministry. We consult with them on the terms of reference, we consult on who we think are the likely core stakeholders, and then finalise the terms of reference. So hopefully that answers your question. There's some discussion about the projects that we get, but once we get them, then we determine how we go about doing the work and answering the problem. The second question, I think, was around lobbying. I'm not very good at lobbying for implementation of our work. It's something that we raise in our regular meetings with the Ministry of Justice. We keep a schedule, another spreadsheet of our past law reform work and where we're at with implementation. The issue there really is a resourcing one. So the vast majority of our recommendations are accepted. The thing that often holds them back is resourcing and priorities, and that's really out of our control. You know, and often the message is, oh, we would really like to be working on this, but we've been asked to do this and we have to do that first. So that's a tricky one. I'm not sure that there's much more that we could do other than maintain good transparency in terms of what projects have been implemented and which ones have been accepted, or which ones the recommendations have been accepted but yet not implemented. We publish that as a schedule to our annual report. The third question, I think, was about Te Hungaroia. So in the middle of last year, I think in July or August, we signed a memorandum of understanding with Te Hungaroia, which was great, hopefully for both. The MOU was intended to shape a framework for ongoing cooperation. So we recognise that, you know, Te Hungaroia is a voluntary organisation and people are incredibly busy and they don't have necessarily time to write long submissions on our projects. But on the other hand, their contributions are very important. So through the relationship that we've tried to foster through this MOU, we have regular meetings with people from the exec to tell them what work is coming up. And we're happy to take submissions in different ways. So whether it's recording a phone call, or whatever. We participate as we can in their own activities. So, for example, going to the Whātua and talking to people about law reform there. So difficult, just because in the case of Te Hongaroia, and I shouldn't really speak for them, but my observation is that they're just all very busy and demands on their time right now are quite high. So we see it as part of our job, really, to try and make engagement with them as easy as possible for them. In terms of the tikanga project, no, I can't say any more about that, other than the fact that it's been referred to us. And when the judge starts on it next week, one of the first things on his list will be to scope the project and work out what resources are required. But he doesn't start until Tuesday, so we've got a bit of time, or he has a bit of time to work out what that project is going to look like. I think that was all, Joel, from Hannah.
Yes, no, that was excellent. Nicole Morham has another question, but it's also about the Tikanga project, asking about its aims and scope. But I think you have answered that. And then and Hannah say thanks for the answer. We are almost out of time. We have still a few minutes, but I don't see any. I see another question here. So this will probably be the last one. And then I'll give you a couple of minutes to say any final words if you wish. But this has really been great. I think this. I really enjoyed it. So this question is from Rob. So he says, is or should there be an active relationship exchange between the Law Commission and Royal Commissions to scope legal failings or contentious issues, both in how Royal Commissions operate as a matter of natural justice, witness-based, and the issues they identify arising out of inquiries?
That's quite a big question. The short answer is that on the list of law reform ideas I mentioned before, I'm pretty sure that someone has suggested that the Law Commission look at inquiries. I don't know enough about how they are conducted to really be able to respond, but certainly if there are issues, if it isn't already on our list of things to potentially look at, then it probably should be. And maybe that's one of the useful things of this exercise, Joel, is actually letting people know that we do maintain a list of possible law reform projects. And it ties into what we were talking about right at the start in response to Mike's question. In terms of our capacity, we have quite limited capacity now to pick up new work. Partly because commissioners are only part-time law reform and a lot of their time, particularly my time, is taken up doing other things. So so I don't really have a good answer to that question, other than to say that there are many things that we could be looking at, and there are many things that people would like us to look at. Other suggestions on the Great Law Reform Project Ideas list are taking up the charities review, reviewing the ACC legislation to Ture Whenua. They'd all be massive projects, and we probably couldn't do them with our current capacity.
Thank you very much. We may have actually time for one more question if anyone wants to ask. So so I think that's we've reached an ideal situation. We're almost out of time, and we have no questions. So that's great. I mean, we have reached the end of the event, but before closing, I just wanted to ask Amokura if you have any final words before we thank you and close.
No, not really, Joel. I think we're very grateful for the support that we have from law schools across the country, actually. We often have people who participate on our expert advisory committees, who do peer review of some of our work. So I think, just by way of closing, I'd like to say thank you for for the academic effort on our work, but also we cite academic work all the time too. So acknowledging, slightly self-interested because I was an academic, but also I just wanted to acknowledge the value that academia provides to our work here at the Law Commission.
Thanks very much for that, Amokura, and thanks again for this really excellent lecture. And thanks everyone for your questions and comments. And please remember to keep an eye on our website for future events. Thanks again, Amokura. I hope to see you soon again. Kia ora, everyone.
Kia ora.
Bye.
Bye.